Welcome to Behind the Scenes. I am your host, Hector Montalvo. This show is dedicated to asking tough questions for you, the viewers. We bring you their responses, and we let you decide. Joining us here today at our MCTV studios, candidate for Governor's Council, Mr. George O'Brien. Mr. O'Brien, welcome to the show.
Thank you, Hector. It's good to be here.
Thank you. Mr. O'Brien, can you explain what the function of the Governor's Council is for the viewers?
Yeah, a lot of people don't even know the body exists. It goes back to colonial times. Lost a lot of power in 1958 or so, but it still has a very viable part in the government of the Commonwealth of Massachusetts. Its chief and most important function is to allow or deny the judicial nominees of the governor. It has a minor role in paroles in the sense that that role has pretty much been overtaken by the parole board, and it confirms justices of the peace. And it's a power that hasn't been used, and there's probably a way of using it in today's world. It also can stop payment in any check that the Commonwealth issues. In 1790, that was pretty important. There wasn't a lot of payments issued by the state government. But with the age of computers, perhaps that can be brought back. That has both good points and bad points. The good points is if you keep hearing that a particular project, and I'll pick on the Big Dig, is particularly bad, maybe you can slow some payments down and find out what's going on. The bad points is if somebody's very petty and doesn't like a state official or a state employee, payment can be stopped because somebody doesn't like somebody.
Right.
So.
Now, why do you want to be on the Governor's Council?
I'm a lawyer by profession. I think the courts in the Commonwealth of Massachusetts have become extremely conservative. I want to change that. I think the little guy is entitled to his fair day in court, a day in which on the civil side it doesn't cost $350 to file a complaint. If an insurance company, defense counsel usually, wants medical records, you sign as it was, you sign a slip and they're responsible for paying for it. That was in Rule 33. Rule 33 has been substantially changed about 5 years ago, I'm not exactly sure of the date, where if they request medical records, the little guy is responsible for it. Doesn't sound like much, but to open a medical record is $68, and oftentimes it's $1 a page. Oftentimes, the hospital that you had the operation at or the procedure at or went to has several subdivisions that now keep their own medical records, and it's just tough to find. It's very hard work, and it shouldn't be borne on the little guy because the big guy wants information that may or may not be relevant.
Now, when did you realize that you wanted to be on the council?
Really, there was a case that broke the camel's back with me. I had people who were very horribly injured in a car accident. Total medical bills were $500,000, not my client, total of the people in the car. My clients were about 45. They had minimal money. Mom was a waitress. Dad worked as a small job in state government. It was tough to pay the medical bills that insurance wouldn't cover. They came to me. The car my client was in had minimal insurance. The car that hit them, which wasn't driven by an owner, the owner claimed that he had left the car unlocked in a questionable area of Salem, and there aren't many questionable areas in Salem, but in this case there was, and somebody got in the car and drove away. He called about the accident 5 minutes after it happened from his house, which was about a 3-minute run away. There's some suspicion there, in other words. But anyway, I got the automobile insurance, and one of those insurers wanted to deny. One of the driver's mothers had a home for a little while during the time that this took place. I filed suit against the homeowners company, arguing that Mom was negligently supervised. Now, you can argue about the theory all you want, okay? And it was going to be a tough case, and I'll even concede that. The insurance company got up on its hind legs and said, not only are we not going to defend, we're not going to pay. So I got the judgment. Waited 30 days, as you're required to do in Massachusetts. Court assessed damages that were substantial. The insurance company, 3 months later, and you can't do it in Massachusetts law decided they made a mistake, filed a motion to revise and revoke. The judge allowed it. It's contrary to every case law, every case in Massachusetts, every appellate case in Massachusetts within the last 5 years. I did take an interlocutory appeal, which is difficult in Massachusetts. I do appellate work in some cases. The court said, well, this was the final resolve, so you have to try the case. The maddening part about the case, when I researched the law, every case that was against the person seeking revocation of a judgment in the same category was always a small law firm until today, and they were always denied. And I think if you look at the appellate court, excuse me, let me go back. If you look at the appellate court decisions, over the period of the last 10 years, they've been enormously kind to big business, enormously kind to big insurance companies, and enormously unkind to the little guy that I represent. And that was the case that broke the straw, that broke the camel's back.
Do you think the courts today are doing a good job?
Well, you have to define good job. Do I think that they've become too favorable to big business? The answer is yes. Do I think they should be kinder to small people? Because there's a difference. If big business wants to pursue something to the end of the earth, they can. They have the financial resources. If a small guy sues, you know, you have to think about how much is it going to cost for depositions, how much is it going to cost to summons and witnesses, how much time your clients can devote to the case, how much time you can devote to the case. Big business doesn't have any of those problems. And I don't think those problems are taken into account in the procedural rules that have changed or the judges' attitudes that have changed, because many of them come from big law firms, and their perspective is entirely different.
Now, if you are elected to the Governor's Council, your main function would be appointing the nominees that the governor comes out with. And just recently, the governor has come out with 3 additional nominees, one going into the Supreme Judicial Court, some going into the District Court. I want to quote something on your website. Sure. That you specifically say that you will only confirm Supreme Judicial Court and Appellate Court nominees, okay? You also say, who remembers that the Massachusetts Constitution requires adequate funding for education. Can you explain that? Sure,
absolutely. I'll have to go back 2 court cases, okay? But there was a decision, I believe it was the McKean decision, maybe McCade, of about 25 years ago, that stated the state constitution mandated adequate funding for education. Brown, I think it was Brown, there was a case that interpreted that the plaintiff won, but the ball seems to have been dropped. 5 or 6 years ago, I'm sorry, I just don't remember the name of the case. 5 or 6 years ago, adequate funding of education changed, so that there was a period of budget cuts in education. They were allowed, I believe the State Teachers, I know the State Teachers Association took it to court. They won the Superior Court by a person who's on the Supreme Judicial Court now, and went to she was at that time a Superior Court judge. It went to the Supreme Judicial Court, and the vote was 5-4. It's okay. That sounds okay. There was a 15% cut across the board. But you know what? It didn't work very well. I'm going to pick on Hamilton and Wenham because I know, okay? The Salem Evening News covers Hamilton and Wenham quite well. Whenever a program was cut or proposed to be cut in Hamilton and Wenham, somebody stepped forward with a check. There were no programs cut in Hamilton and Wenham, or if there were very few. Whenever the same thing happened in Danvers, a municipality known to be fairly well off, most of the time the program got sustained. Somebody came forward with a check or money was found somewhere. When the same thing happened in Salem, a community not so well off, 50% of the time the program somehow existed. Somebody came forward with a check or money was found. When the program came to Lynn, a community that, you know, is literally the United Nations and has a different body and has much less money, it almost never got sustained. It got cut. And Going from that to education, this last year, a person from Lynn Classical got into MIT, and that was the headline. The story was it was the first time in 20 years. Next day, or approximately the same time, there were 6 from Marblehead that got into MIT. I'm not begrudging anybody from Marblehead who got into MIT, but I am suggesting that Marblehead, which is a well-off community, was simply able to afford programs that enabled their kids to advance. And if we have public education, everybody should have at least some sort of near equal footing. Recently, in this district, in the Groton High School, we had to raise $133,000 to go to London to sing. The choral group, $133,000 was raised in 3 months. If the same honor had been bestowed on the city of Lawrence or Methuen or Haverhill or Salem, I doubt $133,000 would have been raised privately in 3 months. Wonderful opportunity, and I congratulate the people of Groton both for doing it and their kids for being that talented. But the kids from Lawrence, Haverhill, Methuen, Salem wouldn't have had a chance. Not fair.
Now, we know that the Commonwealth of Massachusetts and the judges who are appointed by the Governor's Council hear restraining order cases in the court system.
Yes.
We know that Massachusetts court system issues 35,000 restraining orders per year.
Actually, I didn't know that, but I'll take your word for it.
The SJC has ruled that children cannot be added onto a restraining order unless there is accusation of abuse by a defendant onto the child. Will you be asking nominees that come in front of the Governor's Council if they have ever complied to this ruling?
I would ask it, and you know, if whatever the answer was, I'd delve a little further into it, and I can't tell you which way I'd vote because a lot would be what the nominee in front of me said or didn't say, or maybe even how he said it. You know, if he said it in a way that I was suspicious, I might delve a little bit quieter, not in front of the council, but I might try and find out where, what, and why, and how it happened.
Now, have you gone into court to review how these judges are actually doing their jobs?
I haven't done it to every judge, no. Oftentimes, I used to have, I'm not so much now, I used to have a very active trial practice, and oftentimes, you know, you just talk to people and you find out which judge was favorable to a particular thing or which judge wasn't favorable to a favorable thing, and it was always true.
Now, let me ask you this. We understand, and it's been verified through public records and freedom of information requests, and also confirmed by the court system, that the court system and the Department of Revenue have a $3.5 million contract so that the judges of the court system hear their cases. Who would you say wins 99% of those cases?
Always the Department of Revenue.
Why is that?
Because they just believed. They just believed we're in an era where if you have a problem, it's almost impossible to explain it. And it's beginning to change a little bit. People are beginning to understand that, you know, people get laid off from work. Work isn't what it used to be. People have been asked to take pay cuts. But until very recently, that wasn't so, and it was just presumed that, you know, you weren't paying your child support payment or you weren't paying your alimony, and it was your fault.
Now, if you're elected again, you'll be voting on nominees who are going to become judges, whether they are in the district court. We know that you stated that you would not vote for anyone unless it's the Supreme Judicial Court or the Appellate Court.
Well, that was limited to those 2 courts because I consider that extremely important. I consider it fair play. I consider it a way for people to get ahead. And I think when you're not funding the schools public schools adequately, certainly, or any school for that matter adequately, you're depriving somebody of a chance to get ahead. Now,
the current Governor's Counselor, Ayala, he's a Boston Democrat, and I just want to quote what he said on a recent article from the Boston Globe, okay? He basically said that he has never opposed an SJC nominee in 24 years.
That won't be me.
How will you ensure your constituents that you will not be rubber stamping any appointments?
Anybody who knows me knows I won't rubber stamp, okay? No, I won't. I won't. Does that mean I'm going to automatically oppose either? Absolutely not. But if I think somebody is really, if I think I have a problem with somebody beforehand, even before I begin research, I might go to the governor quietly and say, I might have a problem with this guy, you know, can you do something?
And what do you seek to gain by joining the Governor's Council?
A competent judiciary, a judiciary that maybe will understand that people can't afford to pay $350 to file a case. A judiciary that maybe will understand that Rule 33, as it is now, might have to be modified. You know, a judiciary that's fair, a judiciary, and even maybe a judiciary that's a little bit tilted towards the little guy because the resources are different. That's all. I'm 63 years old. I don't think I look it. Maybe I do. I might be kidding myself. I'm not going to the bench at 63.
Now, you talk about the disadvantage that the little guy may have entering the court system in regards to fee and so on. But we do understand that the court system is also creating debt prison all over again, where they're incarcerating non-custodial parents for the simple crime of being broke. How would you take that into consideration when you're considering a nominee, whether or not there's been complaints, appeal courts, rulings against these particular judges? How would you hold that particular judge accountable before voting to promote them to a higher?
Well, again, that involves more investigation. The first place you look at is the resume that was submitted. The second place you look at is the cases that they've handled. The third place you look at, because there may be somebody from the Department of Revenue that has to do it, the third place you look at, if you can, now this gets difficult, is the recommendations they made to the judge. And the fourth thing you look at, again, if you can, because this may get difficult, in fact, let me rephrase that, this is difficult, is the fact pattern of several of the cases.
Now, we noticed, we covered the Governor's Council a few times on this show, where we've gone to Beacon Hill on a Wednesday, because they do go on a Wednesday and they hear two nominees, and then they come back on the following Wednesday to make the actual vote. In doing so, we've noticed that nominees usually bring in government elected or appointed officials to speak on their behalf. You'll see the Attorney General, you'll see some of the Chief Justices of the court making these recommendations. Should the Governor's Council be listening to these type of recommendations from elected officials or appointees that may benefit them down the line if a particular judge that they're advocating for is appointed?
Well, yes, but you hit the nail on the head too. In the back of anybody's head should be, why is this guy here or woman here? Why is he or she supporting this candidate? Is there something going to happen down the line that's favorable? And depending on the answers to those questions, you either place great faith in that recommendation or not so great faith in it, and then you go back to, is he competent? What's his resume say? What's he done and how's he done it? Again, that's the difference between rubber stamping and asking, you know, and letting these people say, yeah, we think he's a wonderful guy. That's open to everybody, by the way. Anybody can come in. But I've never heard anybody come in and stand up and say, no, this guy isn't anybody that I would want to be my judge. And I've never, and rarely do they, as you know, because you've been there, rarely do these people bring in average Joe on the street saying he's a wonderful guy. And you know, some of the problem, I think, I'm not entirely sure, but I'm reasonably sure, some of the problem is the Judicial Nominating Committee isn't what it used to be. When it was first started, it was started by Frank Sargent, and whether you like Republicans or Democrats or anybody else, Frank Sargent's judiciary was outstanding. But Frank Sargent really started the Judicial Nominating Committee to sort of overcome the huge Democratic majority in the Executive Council, Governor's Council. And he would go out to towns where there was a judicial vacancy, or the Judicial Nominating Committee would go out to towns and where there was a vacancy and say, what do you think? And more often than not, Frank Sargent had lobbied. At those days, the judiciary wasn't well paid. Would lobby somebody and say, I know you'd make a great judge. People have told you you'd make a big judge. Let me put your name in nomination. And they would go out and get an opinion. And it was wonderful. It worked well. Since that time, you no longer have to be a resident or have a law practice on the place you're sent to. And even if you're nominated to be the judge of the Methuen court, and I don't think Methuen has a court, my recollection is it goes to Lawrence. Even if you're nominated there, once you're you're now a state judge, a bidding process starts, and whoever wins the bidding sits at the Lawrence court. And I'm not sure that the lack of local control is a good thing, and I'd like to go back to those days. And I think the place the Governor's Council ought to be is perhaps the overseer of the court system, and you really don't have anybody that is the overseer of the court system right now. Yes, you have a Judicial Complaint Committee, but unless somebody is awful, you never hear about it.
Exactly, and let's talk about that for a second,
Sure.
because there is such a committee that does hold judges accountable, but yet when
Whoa, I'm going to disagree with you there.
they're supposed to hold judges
Okay.
accountable, yet the complaints are never made public. So no one actually knows of the complaint or even the investigation of a judge. How will that come into play when you're deciding whether or not you're going to vote for a particular nominee?
Well, oftentimes you wouldn't hear it, and oftentimes you couldn't get the information. The only way you could get the information really is if something happened, and that would be a nominee who would be trying to go up. But oftentimes, again, you couldn't get the information, and if you could, oftentimes it's because the press covered it more than anything else, not because the judicial people came forward and said this guy had a complaint. But life isn't made of perfect people, and I'm not saying I would vote for anybody that had a significant, certainly I wouldn't vote for anybody that had a significant complaint. But a minor complaint, I might ask, okay, what happened and what did you learn from it? And if I liked those answers and the resume was fine and the guy had a pretty solid judicial background and was fair and reasonable, I might give him a vote despite it. Probably would, as a matter of fact.
Now, as it stands right now, SJC Rule 119 allows the judge discretion whether or not to allow cameras in the courtrooms.
That's correct.
The SJC has been working not only with my program, but also with other members that I'm associated with, to bring cameras into the courtroom. They started doing that in the federal courthouse, and we're supposed to be bringing that into the Commonwealth of Massachusetts. I know Dorchester started it, and I believe it's going to expand next month. In the month of September, it should be expanding. Are you in favor of open courthouse, open so the viewers, everyone that don't have access to the courthouse, can actually view what goes on in the courthouse from the comfort of their own home?
25 years ago, I'd have said no. Right now, I would say yes. I would certainly do it on an experimental basis, just in case witnesses get enamored with the camera or get panicked by the camera. I don't know how most people are going to react in front of the camera. I think by today's actions, you can tell I'm comfortable with the camera. But I had a show like yours in Salem for 5 years, and I began my career as a trial lawyer, as a public defender in the Salem District Court, which was the 10th busiest district court in the state, back when Salem was much poorer than it is now. So, you either get very comfortable in front of people in that type of an occupation, or you die, or you leave it. So yes. Yes.
Well,
I think incidentally, I think it would work because I think we're beyond that point. But I'd like to have a year experiment just to make sure.
what do you think of the treatment of non-custodial parents in the courtroom?
You know, it varies. It depends on the judge. It depends on the fact pattern the judge has been presented, and it depends on the judge's gut. The probate court laws generally are wonderful written down. We've had some judges, particularly in Essex County in the past, that weren't so talented, okay? A talented judge will probably treat a non-custodial parent pretty well. There was a time when, frankly, men were treated very badly. That's changing. It's changing for the better, and it is. It really is.
I haven't seen that, but
okay.
I
have some faith in the present judiciary in the Essex County Probate Court. I do. There was a time when I didn't, and I think it will straighten out. It may take a little bit more time, but I think in the end it will straighten out. And it doesn't work if a man is brought in every 2 or 3 weeks, or a woman is brought in every 2 or 3 weeks to keep litigation going. And maybe there's not enough realization of that in the courts.
Will you be, if you're elected, will you be, if you get a call from a constituents to come down to the court system and just observe?
Yes, absolutely.
You will be attending those.
Absolutely.
How does, if any constituents want to reach out to you, is there a Facebook page or a phone number? If you can do that within 30 seconds, that'd be great.
Sure. My Facebook page is my own. It's Judge Thomas O'Brien. I have obviously an email address, judgethomasob@aol.com. My telephone number is 978-532-6534. My law office is 24 Main Street, Peabody, Massachusetts.
Great, and we wish you a lot of luck out on the campaign trail, September 6th, Governor's Council.
Thank you.
For the 5th Essex District, correct?
Correct.
Before we go, we want to take this opportunity to thank each and every one of you, my viewers, whether you're watching us on Comcast Channel 22, Verizon Channel 33, Facebook, Twitter, or even YouTube. The support that this show has received on almost every topic we discuss is greatly appreciated. Keep those emails and phone calls coming in. Remember, we ask the tough questions, bring you their responses, and we let you decide. In doing that, this show has won a national award behind the scenes in the category of Democracy in Action, and we thank you at home and you, the viewers, for watching. So on behalf of my National Award Director, Jack Burke, my floor director, Valerie Garuso, camera crew, Bruce Wilson, Barbara Stella, the staff at MCTV, thank you for watching Behind the Scenes. Join us next time as we go behind the scenes to ask the tough questions, bring you their responses. We let you decide. Thank you for joining us.